to another seminar series talk. It's my profound pleasure today to give a brief introduction to our speaker, although he doesn't need any introduction at all. Professor Joseph Sung-Yeo Park is a full professor at National University of Singapore, and he has written widely and extensively and influentially in linguistic anthropology, social linguistics, applied linguistics. I actually am going to ask him to stand up now and simply start his talk solely for the fact that I think most of us are familiar with his work. And if not, I have no doubt that you have read his name in writing and are familiar with any of the 3 monographs he's published or any of the many influential papers he's written. So we'll get started so that we have the maximum amount of time to both hear from Professor Park and hopefully have a lively discussion at the end. So please join me in giving a warm round of applause to our speaker today, Professor Joseph Sung-Yeo Park.
Okay, thank you very much for the introduction. Thank you very much for the kind invitation for me to come here. So it's really my pleasure to be here at Hong Kong Poly U and to be back in Hong Kong as well. That's my favorite city. So what I'm going to share today is kind of a preliminary kind of work in progress. It's something that I was hoping to work on for a while, but haven't really developed very much. So it's very kind of rough and preliminary. So your feedback, any comments, thoughts you have would be useful in kind of helping me kind of move this thing more forward. Okay, so let me just get my stuff out. Right, so what I want to talk about is to okay, yeah. So what I'm interested in kind of exploring is to think about intellectual property in terms of commodification language. So basically, I believe you're kind of familiar with the notion of commodification language, right? So this has been a quite extensively discussed topic within the field of social linguistics recently, which is basically about how language is coming more reimagined in terms of economic resource in the context of neoliberal transformation of society. And so commodification language literature has been talked about various kinds of specific phenomena to discuss this, notion of commodification language. But one thing that was kind of notably missing, but nonetheless, what I think is quite relevant to the commodification language is intellectual property, right? And I say this because the way I see it, and I'll kind of talk about it a little bit more, intellectual property could be understood in a way in which discourse gets subsumed under the notion of property with this kind of exclusive rights, and texts get kind of extracted, text or knowledge or discourse about things get extracted out of the natural flow of discourse to be subsumed under, capitalist market principles, right? And of course, this is also something that is much more enhanced in the context of neoliberalism, right? Because many companies and for many business interests, the notion of intellectual property is something of a kind of a golden egg-laying goose, so to speak, right? So it's because it's kind of can lead to kind of this production of profit and so forth, right? So there's obvious connections with the commodification language, but there has been relatively little talk about intellectual property within the context of social linguistics and linguistic anthropology. It's not to say that there has been no research, but there has been, for example, work by Lee Tong-king, who talked about translation and copyright, or Konstantin Nakasis's work on trademarks and branding within linguistic anthropology. And there have been several legal scholars who were not linguists themselves, but use the framework of semiotics to talk about these intellectual property issues, like David Tan, who's my colleague at National University of Singapore. But other than that, there have been very little kind of work on social linguistic work on intellectual property. And I don't think, as far as I'm aware, there hasn't been any connection made between intellectual property and commodification language. So that's one gap that I'm trying to kind of fill here. Now, of course, intellectual property rights are not so much natural rights, right? And it is a highly political thing, right? And within the discussion of, they talk about the history of intellectual property and its development, it has been subject to much debate, right? And intellectual property concept itself within legal studies also talked about in terms of this tension between the right to exclude others from using the cultural product that you have produced, right? So for example, right to exclude others from using an original expression that you developed in terms of copyright, for instance, or an invention that you made in terms of patent, right? Or the brand that you develop for the products that you have made, right? In terms of trademark, right? So these are the three kind of key areas within intellectual property, right? So on the one hand, the idea is that if you want a culturally vibrant society, we need to encourage people to produce these things, cultural goods, and then allow them to be rewarded from it by giving them some kind of exclusive rights of control of these cultural products they made, right? But of course, that needs to be balanced, because if the owners of these rights, holders of these rights, start to kind of exercise a monopoly on the cultural goods that they produced, then there's really no point, right? Because everybody should be able to use those ideas and cultural goods in order to, develop them further for a more culturally vibrant society. But if such rights are unlimited, right, and somebody can have a monopoly on the ideas, for example, produced in a book or a invention under a patent, then we cannot expect any further development of these ideas, right? So these rights also need to be limited, right? So for example, only certain things can be patented or copyrighted. And if something is patented or copyrighted, there is also expiration date to it and so forth, right? So intellectual property from its conception has been sensitive to these kind of political issues, right? And then intellectual property of the design of the laws of intellectual property has always paid attention to this tension between the notion of exclusive rights and the public good, right? And many critical legal studies on intellectual property have often kind of criticized how, particularly recently, there has been a gradual shift towards the balance towards the exclusive rights side, right? Because, for example, in terms of copyright, recently, there's more pressure to extend the period before a copyright expires, right? So now it's kind of quite a long time until copyright expires on anything, right? So, for example, lots of critical scholars have been arguing for we need to kind of shift the balance backwards, right, to expand the space for the public domain, right? But what I'm thinking is there's also room for a socio-linguistic perspective to kind of contribute to this critique of the notion of intellectual property. So for example, questions that I have in mind are, what are specific mechanisms through which the notion of intellectual property comes into being in the first place, right? And how is it that discourse comes to be imbued with this notion of economic value to begin with, right? I don't have a explicit answer to these questions yet, but I think these are some questions that a sociolinguistic and discourse-based approach to intellectual property can be very helpful in answering, right? And I say this because the way I look at it, I'm trying to approach intellectual property as a meta-discursive regime, right? So as I said at the beginning, the way I see it, intellectual property can be understood as a process whereby we extract language or discourse from its social embeddedness, right? And then we regiment it into circulatable chunks and then attribute some ownership to fit the framework of property, right? So discourse and language is really something that's so deeply embedded in our social practice. So it cannot really be separated out of that context or can be attributed only to a single person, right? But nonetheless, within the framework of intellectual property, we are kind of forced to do that. We're forced to do that, right? And this kind of leads to various kinds of issues within, the legal scholars have been critiquing in relation to intellectual property. So for this, I think the frameworks, linguistic anthropological frameworks of interdiscursivity, for example, can be useful to talk about this because it also deals with how the flow of discourse across interactional events gives rise to new meanings and values. And the work by Briggs and Bauman, for example, talk about the process of contextualization and recontextualization that needs to happen in any kind of circulation of text, right? So intellectual property regimes are doing that precisely, but particularly in reference to a specific kind of ideology of language, which I talk about in terms of language as abstract communicative code, right? So in the way I see it, the intellectual property regimes work on the basis of the notion that language can be seen as an abstract communicative code that can be simply used as a conveyor for meaning that pre-exists separately from the language itself, right? So in this sense, language is simply an abstract communicative code that can help that process of, extracting discourse out of its social embeddedness, right? So I think this is kind of one way in which sociolinguistics can contribute to a critique of intellectual property. And as a way of doing this, what I have in mind is something of this is an idea that I've been trying to develop for some time, but I haven't been able to very much. Basically, the idea of what I'm calling language as doing, right? The notion of doing that I'm talking about here is something I'm borrowing from the work of a Marxist scholar, John Holloway. And basically, this is the idea of doing is something that Holloway develops based on his reinterpretation of Marx's work on abstract labor versus concrete labor, right? So in Marx's framework, there's concrete labor, right? So if I'm a worker and I construct this computer through my labor, right? I'm not just doing this as anonymous labor, but there's real human interaction and creativity and transformation of action that is going into my production of this particular product, right? Even if I'm working on a factory as one of the nameless workers, I'm still kind of putting my sweat in, and I feel there's affect that drives me to work and all these kind of life experiences as part of that production of that computer, right? So that's concrete labor, right? But then when the computer goes out into the market, all the people can see is simply the abstract labor that went behind this computer, and they don't see my story as a flesh and blood worker, right? And all they see is some kind of abstract kind of value that's behind this, which can be simply transferred into a simple wage per hour that went into the production of the computer, right? So that's abstract labor, right? So from Holloway's framework, what he's talking about is that part of the concrete labor that can be understood as doing, right? So in this sense, doing can be understood as a creative, transformative, and self-determined embodied action, right? Which is a manifestation of humans' capacity to do what they find meaningful and desirable, right? So, I was thinking, well, language can be understood as doing, according to this idea as well, right? Because when we interact with each other through people, either through our labor or our leisure or whatever, ordinary social interaction, we are creating value in social life through the communicative actions that we carry out, right? Because we're constantly negotiating our social relations, our affects, and we're creating meaning in social context, and that kind of gives rise to certain values, right? And what capitalism does is exploit this by transforming that into abstract labor, right? So let's say if I'm a worker at a call center, the context that's typically often discussed within the commodification language. Of course, again, I'm just a nameless worker in this call center where there's thousands of workers, right? But nonetheless, when I'm talking to a customer over the phone, I'm still kind of doing something with the worker through my interaction through my interaction with the customer, right? I am kind of building some kind of relationship with them and kind of trying to negotiate how we feel and also things. And even when I'm participating as a very bored worker who doesn't really care about the job itself, nonetheless, there is some kind of interaction thing going on within that specific interaction, right? And that's what gives rise to the value, not simply the certain set of fixed hours that I simply sat there at the terminal just answering calls, right? So I think that's also one useful way of thinking about the commodification of language, right? Because it can also help us explain where does the value of the language that is being commodified coming from, right? That is coming from this language as doing, this embedded social communicative actions that we're carrying out in whatever context that we're in, right? And I also think that can be a useful way of critiquing intellectual property because basically then we can understand intellectual property as a process through which the regimentation of discourse into isolable property is carried out through this erasure of this aspect of language as doing. Okay? So that's the kind of rough, broad idea that I'm interested in, and hope in the following things I'm going to share, this becomes a little bit more concrete. Okay, so the specific stopped. Okay, thank you. Yes, so the specific example that I want to talk about is what's called the idea-expression dichotomy, which is basically a key idea within a copyright law that suggests that copyright protection does not extend to ideas, but only to expressions, right? Okay, so this is a basic idea within copyright law. It's one of the kind of basic things that you learn if you start learning about copyright law, right? So, so all the textbooks on copyright law talk about this idea, and of course, this idea itself is enshrined in various kind of legal texts. So, for example, in the U.S. Copyright Act, we have this kind of clause that says, in no case does copyright protection of an original work of authorship extend to any idea, procedure, process, system, or method of operation, and so on, such and such, right? It's only the expression that is actually protected under copyright, right? And this idea is kind of mostly derives from Anglo-American kind of copyright law, but because of the influence of the US and the UK in global copyright intellectual property regimes, these are also kind of referenced in, also present in many international intellectual property agreements that have, worldwide kind of effect, right? So for instance, in the what's called the TRIPS agreement, which is a agreement that on intellectual property for all the World Trade Organization member states, right? Also states copyright protection shall extend to expressions, but not to ideas, right? So basically what this does is that this is supposed to address the tension between exclusive rights and public goods that I was talking about earlier about intellectual property, right? Because the idea is that if you restrict the use of ideas and create a monopoly of ideas for the creators, then that'll exclude them from being used and circulated, and that will stifle further innovation. Right? So what we should recognize under copyright should be the particular expression that is created by the author as their work of innovation, okay? So in this sense, it kind of ties in with that tension between exclusive rights and public goods, right? So one kind of classical example that's often discussed in relation to this is a late 19th century case called Baker and Selden. So this American kind of legal case that was quite influential in kind of later cases. So basically what happened is that this person named Selden has created a book, he basically developed a new method of bookkeeping, and he published the book, which contains of many blank ledger sheets like this. And then the book basically consists of various kinds of many sheets of this kind of ledger, right? And it had an introduction and some text that explains how this ledger works and so forth, right? But what happened was, several years later, a person named Baker kind of took this and made some modification of this ledger form, and then started selling his own books, right? So the Selden, Baker's book actually sold better, right? So I think Selden's widow, after Selden died, kind of sued Baker for copyright infringement, basically, right? So the question was, if you copy a blank ledger sheet like this, does that count as infringement of copyright? So the decision was it does not, right? Because this ledger sheet is basically the whole idea that Selden's book was supposed to describe, right? So if you prevent people from copying this ledger sheet and using it and developing further, then that will lead to the effect of stifling of further innovation, right? And in fact, the fact that Baker's book sold better than Selden's original ledger sheets might mean that, in fact, if Baker was not allowed to do this, then in fact we wouldn't have had this better version of these kind of ledger sheets, right? So it kind of illustrates the point that the idea expression dichotomy is trying to make, right? So basically, what this idea expression dichotomy does is that this often serves as a heuristic in many copyright cases, because when the first thing that the judges need to do is to decide whether what is being copied is indeed something that can be protected by copyright, right? So in kind of making that decision, this idea expression distinction is often used, right? Because you just need to think about what is what's being copied. Is it the idea or is it the expression? If you're copying the idea, then it's okay. If you're copying the expression, then it's not okay, right? Um, but of course, things are not that straightforward, actually, right? And in reality, there have been many discussions about the problem with this dichotomy, right? Because in reality, of course, the distinction between ideas and expressions is not straightforward, right? Of course, from a linguistic perspective, we might say that, okay, so idea and expression can be distinguished, right? So for example, we have the word dog, for example. You might say that's an expression, and the idea that it refers to the animal dog is the idea, right? So you have that distinction, right? But of course, we also know that that kind of binary is often problematic, right? So, and that's what, for example, Peirce's on semiotic framework tries to talk about, right? So it's not this kind of two fixed signifier and signifier that's linked together to the sign, but the relationship between the two is much more dynamic, right? With each other shaping each other constantly, right? And evolving into new meanings, right? So yes, so the distinction between ideas and expression in reality is not straightforward, right? And particularly as copyright now gets extended to not just written text, but many different cultural forms like plays, music, or images, or performances, or software, then increasingly this boundary becomes more and more fuzzy. So how to resolve this problem was widely debated in copyright law. And we do find many legal scholars just pointing this out. For example, this article by Jones says, no expressionless idea exists, and it makes no sense to speak of idealess expressions, right? Which makes sense, right? So again, so the lots of what many cases on copyright need to do is to find a way to really make the distinction between ideas and expressions, right? And in order to do that, these judges need to come up with some kind of heuristic for making this distinction. And one famous case, this is called the Nichols and Universal Pictures Corp from the early 20th century. So basically, this is a famous case where, so there's first a play called A.B.'s Irish Rose, which featured, I think, there's a Jewish family and there's an Irish family, right? And the Jewish family, there's a son, and the Jewish son, he falls in love with an Irish girl of the Irish family, right? But their fathers are respectively are very staunch Jewish and Irish kind of stereotypical kind of men who really hate the other, right? So there therefore lots of comedy ensues because of this relationship, right? And Cohen's and Kelly's is a kind of a film that came out a few years later. And in this case, this also kind of follows a similar plot, right? So I guess in this case, the Jewish and the Irish relations is opposite. So I guess it might have been the Irish boy and Jewish girl, something like that. Anyway, so it follows a similar plot, right? With similar characters and everything, right? So this producers of this film were sued by the author of the first play as infringing their copyright, right? So in order to solve this, decide whether this is really copyright infringement or not, what the court did was to try to come up with some kind of way of deciding whether what is being copied is the idea or the expression, right? So in this case, what's used is what's later called the abstraction test, right? So what this statement is saying is that, okay, so if you think about the specific storyline of the film, play first, then there's very specific characters and the specific things that they said and the particular settings and all these kind of things. On one level, you can abstract away So leave out some of the details about the character. Okay, so this is just a Jewish boy instead of Jewish boy who did this and this, right? There's one level of abstraction, right? And then another level of abstraction, you might say, oh, this is just a person, just a Jewish guy and this Irish girl, something like that. Another level of abstraction, might even leave that out. And this say something like this play is about this conflict between Irish families and Jewish families or something like that, right? So you gradually abstract away from it, right? And then at some point of the abstraction, you would be reaching what is more of the idea of the play rather than the specific expressions, right? So based on this kind of process, the court decided that this is not copyright infringement. So basically what was copied was something like stock characters, right? Rather than very specific expressions based on specific context, right? And therefore it's not copyright infringement, right? So this is kind of a famous example of how the court needs to struggle to determine the boundary between idea and expression. And this example is also kind of famous for this last line that I highlighted, which basically admits that nobody has ever been able to fix that boundary between idea and expression, and nobody ever can, right? So this is also kind of famous, often reported, often cited, kind of acknowledgement of the difficulty of the boundary between idea and expression. So we see that there's a lot of problem with the idea-expression dichotomy, but despite these problems, the idea-expression dichotomy still is held as a very kind of important sacrosanct principle, right? And there might be some political and ideological reasons for this as well. Because, for example, if you go back to the earlier history of copyright, where the idea-expression dichotomy first emerged, it has this kind of roots in the kind of political rationalizations for copyright that the publishers who are lobbied for stronger intellectual property rights argued for, right? So for example, here I'm kind of citing some paragraph from Warren Bracha, who is a kind of famous intellectual property history scholar. And basically what he's talking about here is, so to talk about the background of history of copyright, back in the 17th century, copyright in England was mostly controlled by the printers' guilds, right? So copyright started out as the rights for printers to reprint books rather than the rights of the authors to protect their own work, right? And the printers guilds had much lobbying power, so they were able to kind of control the printing rights for their own work, right? And they were able to get the government support for that, right? But this changed in the beginning of the 18th century, because in the beginning of the 18th century, in England, there was the Statute of Anne, which was the first official copyright law, right, which brought copyright under the control of the government, right? So on the one hand, this meant that copyright has become something more official, and therefore that's kind of beneficial to the printers. But also it meant that the printers was losing control over the specific way copyright is being exercised, right? Because, for example, under the new law, there started to be more formal expiration date for copyrights. So for example, after 14 years, copyright expire and this will be in the public domain, right? So this meant that the power of the publishers was also being reduced, right? So in the kind of first decades of the 18th century, there was great debate, kind of political contention over copyright, right? So the printers guilds and their representatives were trying to argue more strongly for expanding the reach of copyright, right? So for example, arguing for the perpetual copyright rather than copyright expiring after several years or something like that, right? So what Bracha is saying is that this idea of idea-expression dichotomy often emerged in the context of this debate, right? So when the printers guilds, for example, and their representatives were arguing that copyright should be perpetual, made perpetual, right? They would kind of respond to such concerns by saying that, well, all the knowledge that can be acquired from the contents of the book is still free for everybody to use, right? What copyright does is only prevents the reprints and leaves all ideas unshackled, and therefore it will not lead to a monopoly or constraint on knowledge, even though copyright, the reach of copyright gets extended, right? So in other words, the idea expression distinction emerged historically as an ideological rule in the sense that it represented this particular interest of the printers in the specific context of the 18th century, right? So I think there is something we can add to such critique of intellectual property from a linguistic perspective as well. And that is to kind of try to think about what kind of underlying language ideologies does the idea expression distinction reflect, right? So as I was saying earlier, what I see from this is some kind of reflection of the ideology of language as abstract communicative code, right? So for example, the idea that idea and expression can be separated out neatly, for example, that kind of somehow reflects the idea that words and linguistic structures are simply conveyors for meaning that exists separately from that formal linguistic structure, right? And also, if you look carefully at the many descriptions of the idea expression dichotomy, we can often see that there's this understanding of layered and hierarchical view of language structure. So for example, this is another case from, which is also famous in the discussion of idea expression dichotomy. And here, this judge is saying, well, the right secured by Copyright Act is not a right to use of certain words, okay? Because those are the common property of the human race, right? So what copyright protects is not the particular words of the English language, for example, right? So those are, anybody should be able to use that. So you can't put a copyright on the words themselves, right? And nor is it the right to ideas alone, since in the abstract absence of means of communicating them, they are valued to no one but the author, right? So copyright does not apply to the underlying ideas either, right? Okay. But the right is to that arrangement of words which the author has selected to express his ideas, right? So we can kind of see this kind of hierarchical way of understanding these different aspects of language, right? So on the bottom, there is this words as a very basic kind of building blocks of language, right? And then there's some particular way in which people might put together words to construct a sentence, right? And then there's a level of ideas which kind of are conveyed through the particular combination, a sequence of words, right? So this kind of understanding language in terms of this layered and hierarchical structure, I would say kind of is a reflection of the ideology of language as abstract communicative code, right? So, and also, I'm trying to kind of wrap up soon. I think it's also interesting that the origins of copyrights come from the publisher's rights to publish books. I think that's also kind of quite something that's interesting when you think about the relationship between the idea expression dichotomy and the ideology of language as abstract communicative code, right? Because if you think about it, the mass printed book, which was the kind of very first, the debate over the idea expression dichotomy came out, as I said earlier, because on this context of debating who should have the right to reprint these books, right? And it's interesting that the mass printed book is kind of an iconic representation of the iconic idea expression distinction in the sense that it kind of iconically represents the temporal and physical distance between the end product, the book itself, and the actual intellectual moment through which the author has created some text, right? So what I mean by this is that if you imagine looking at a drawing, for example, it's still a separate object, but you can closely look at the picture and you can see the brush strokes and those kind of things, right? Which kind of serves as some kind of a remnant of the painter's movement or something like that, right? So in this sense, it kind of reminds us that there is a human flesh and blood author behind this art piece, right? And also, if you think of let's say a handwritten manuscript, right? You can still see that it's a separate object, but you can still trace the bodily trail of the author's hand movement and so forth, right? But if you think of a mass printed book, then it's really like an independent object, and there's no immediate trace of the author's work that was put into it compared to a painting or a handwritten manuscript, right? And then it's easy to kind of forget that this was actually a product of the author, but not only the author's own struggle to write a text in his own small office or something like that, but also how these ideas all contained in the book came from the author's own interaction with many different people throughout his or her life, and all this concrete kind of interaction that shape those life experiences and so forth, right? So this kind of fits very well into the notion, the Marxist discussion of the fetishism of the commodity itself, right? So as I talked about earlier, when the computer goes out into the market, all my traces of my own labor that I put into it all gets erased, and we don't see that, right? And therefore we see that commodity as an abstract representation of value, right? So something similar is going on with all these cultural products as well, but probably the mass printed book, I would say, is kind of unique in capturing some aspect in a pretty iconic way, for instance, right? And I think this is, therefore, the talking about the idea, expression, distinction in relation to the discussion of copyrights for mass printed books is actually kind of interesting. And the ideology of language as abstract communicative code would have kind of facilitated such discussion pretty much, right? Because it makes it easier for us to imagine the author's work as simply a manipulation of some abstract code rather than part of some socially embedded communicative action, right? And this in turn makes it easy for us to conceptualize the fruit of the author's labor as a property, right? And the last quote that I have on here is also a very famous quote by Lord Mansfield, who was a very famous English scholar and judge of law, who was quite influential in the shaping of copyright too. In this case, this quote is not talking actually about the idea expression dichotomy itself, but Mansfield is trying to respond to the question of what is the property in intellectual property, right? Because when you talk about property rights for other things like real estate or those kind of things, we can there's specific thing, right? I can say I own this computer because the computer has this physical shape, and I can carry it home and so forth, right? And if I sell it, then it goes to somebody else, right? But intellectual property is different because, of course, the book has a physical shape, but of course, when you talk about intellectual property, we're not talking about the ownership of the book, but what's contained in it, right? So it doesn't have a tangible shape. So if we talk about intellectual property, what are we talking about, really? Okay, so so this quote is responding to the question. And the property in the copy is equally an incorporeal right to print a set of intellectual ideas and modes of thinking, communicating a set of words and sentences and modes of expression, right? And this last part, it is equally detached from the manuscript or any other physical existence whatsoever, right? So Mansfield is actually talking about this in the context of arguing for the greater reach of copyright. So copyright should not be limited, and then, there should be recognized a more perpetual kind of copyright should be recognized, for example, right? In so arguing, he's saying that intellectual property rights exist apart from the hard manuscript itself, but as well as from other kind of physical existence whatsoever, right? And I would, and that probably that's something what Mansfield intended, but what it reminds me of is the other kind of physical and embodied interaction of the author that led to the creation of text. That is also part of that physical existence that we might kind of include in this that's referenced in this quote. That's the way I kind of want to read into this quote. Okay, so basically, to wrap up, then, what I'm thinking is it would be helpful to rethink copyright in terms of the notion of language as doing that I was talking about earlier, right? So the value that resides in a published text derives not from some kind of abstract disembodied intellectual labor of the author, right? But from the more embodied doing, right? So authors are really embodied being existing within society, within social relations, right? So as the author interacts with past and future texts and discourses and other participants, they come to be able to, develop these ideas, which are eventually put into text and circulated further to open up the doors for further interaction, right? And that is actually where the value of these texts that become commodified come from, right? So I think it's something useful to as a way of critiquing the regimes of intellectual property, right? So I think that's one way in which the perspective of language of doing can offer a critique for intellectual property, right? And for the study of commodification language, I guess, again, I think looking at copyright in this way, from the perspective of language as doing, can be a useful way for explaining how commodification language appropriates that value that workers generate through their communicative action in support, and also support, and what the legal and political regimes of intellectual property does is to support and enhance that kind of process of appropriation. Okay? So that's roughly what I want to share today. Thank you for listening. I'll be open to hearing any comments or suggestions for further developing these ideas. Thank you very much.